The court, starting in 1997 with Reno versus ACLU, and then Ashcroft versus ACLU later on in 2002 and again in 2004, come along and say, no. The criminalization of posting obscene material on the internet is too far. It does burn the First Amendment too much.
Welcome to the Debrief with the Washington Examiner. I'm Tiana Lowe-Desher, here with our commentary editor, Con Carroll. Con, it's been a big week at the Supreme Court with a case that, as a justice used to say, you'll know it when you see it. Age verification laws for online pornography.
You didn't want to say the word, but you did. It's
I
pornography.
did.
So, this was a case from Texas, or federal courts, but it's a Texas law. And Texas is actually one of 19 states that have passed age verification laws on for pornography. Now, surprisingly, in many of those cases where states have passed those laws, one company in particular has been pulled out of the state entirely. Not all of them, others have stayed in. But Pornhub has pulled out of every state that has passed one of these laws. So this is a big issue for them. And
but they don't have to do that, is what you're saying.
They don't have to. So there's
Okay.
other online porn companies like Xhamster, who is still functioning in Virginia and Florida and all these other states. But
Okay.
Pornhub has taken, I don't know, could you call it a moral stance?
Interesting.
And decided to pull out, saying it's just incompatible for them. They don't have the resources to do this and still make a profit. God forbid the pornographers don't make a profit. But anyways, so the pornography industry's trade group, the Free Speech Coalition, was before the Supreme Court this Wednesday, arguing against this Texas law. And so you then had Texas's Attorney General arguing for the law. And after listening to the arguments, I really do think that you're going to have a 7-2 victory for Texas, saying that it is not an undue burden on the First Amendment to have age verification for these pornography companies.
Obviously, it's not a one-to-one comparison, but if I order wine from my favorite winery in California, I throw in my driver's license info, they send it to me, it's no hassle. Mm-hmm. So is their argument that just putting in your driver's license number, is it because it relieves you of your privacy? What's their argument for how it's undue burden?
No, this is an excellent question. So what it goes to is the fact that you don't have a First Amendment right to buy wine.
Okay.
Buying wine is not an expression of,
Yes.
of the First Amendment. It's not an idea or anything else. So because pornography encompasses kind of First Amendment protections, First Amendment issues, therefore it has what the Free Speech Coalition is arguing for is that therefore any burden on it should undergo what's called strict scrutiny.
Okay.
So yes, there is, it's not just wine, it's cigarettes, already movies, other stuff like that. So it's definitely something where you have the solutions out there. Other companies are doing this. It's just that the pornography companies know this is too much of a burden for us, and because we're related to the First Amendment, we shouldn't have to go through this burden.
Okay, and then just as a final note on this, reading the tea leaves, because I know you're a good court watcher, who are the two that you think will vote in favor of Pornhub or the pornographers?
Oh, Jackson and Sotomayor. You could definitely tell with their questions. And to give them their due,
Kagan, once again, being the smartest liberal on the bench. Yes.
It does appear this way. They're not explicitly defending Pornhub's right to put out the most vile, hardcore pornography that includes violence against women. We don't have to go into it. It's bad stuff. They're making more of a slippery slope argument.
Okay.
That if states like Texas are allowed to brand certain materials obscene, then they may, for hardcore pornography, they may do it for other ideas.
When does it go to R-rated movies or
other ideas that
okay.
are harmful to minors? You could imagine, Texas saying that a video that promotes transgenderism or gender equality, something along those lines, was obscene. And so that's kind of the direction that they're going to. But at the end of the day, as so many of the justices pointed out, so there were a series of cases starting really from the beginning of the internet in 1996, 1997, up through 2004, where Congress passed a number of laws that criminalized online pornography. But then you had the court starting in 1997 with Reno versus ACLU, and then Ashcroft versus ACLU later on in 2002 and again in 2004, come along and say, no, the criminalization of posting obscene material on the internet is too far. It does burn the First Amendment too much, and so we're going to allow this obscene material to be posted. But you go and you read those cases, and it does seem like it's from another world. You have
Yes.
them saying that Because there's a separate series of cases that talk about how the government can censor and restrict what's on radio and broadcast. And so the court in these internet opinions say, the internet is not invasive. It doesn't protrude our lives like the broadcast does. It's something you have to go out and find, which may have been true in 1997 when you had to go home, sit down, dial up a modem, sign in, all that stuff. But now, I mean, we all know
kids have supercomputers in their pockets.
Everyone has a cell phone that has that's access to the internet 24/7 that has the most horrific pornography on it. So it's just we just live in a different world now than we did in 1997. And from the questions of the conservative justices, you could tell that was weighing on their mind.
When it comes to this slippery slope argument, is this actually when the you know it when you see it would apply? Like where that would be?
I think this is a good point because it gets to where the case is in jurisprudence. So you have this is a facial challenge to the statute, so it has not been applied. So this is an injunction put on before it's been even enforced.
Okay.
And so one of the things that Texas is arguing,
and they have standing because of the potential harm to their revenue model.
Because of the First Amendment, again, because of that, it's such an important right that's being protected here. And so one of the Texas argument is like, look, how about we let facts develop? How about you let us enforce this law, and then somewhere down the road, if you can identify someone who's right to speak on some important issue has been infringed upon, then we can come back and we have this debate. But to just go ahead and enforce this now, when there's no fact pattern to really see, is too early.
Just looking forward, with the new incoming Trump administration, with Attorney General likely to be confirmed Pam Bondi, do we see any other potential challenges to speech-related cases? Do you think Donald Trump will try and challenge New York Times versus Sullivan? Is there anything in the crosshairs that we could expect in the next 4 years as it relates to the First Amendment?
Maybe. I think you could. You had the second Bush administration really kind of pushed, or not the second, the first Bush administration kind of pushed more pornography prosecutions. And like I said before, the standards that were set by the Supreme Court on what qualifies as obscene were set by a very liberal Supreme Court in 1968, 1973. If you prosecuted those same cases today and got before this court, I would say the line would probably be drawn in a different place. So I think there is an opening for Pam Bondi to go in and prosecute some of the worst offenders, particularly against videos that pertains that have violence against women
and websites that liberal reporters like Nick Kristof have found contain minors in the content.
Like what you meant.
Yes.
So go after those people and get those cases into the courts so that we can get a Supreme Court case, because I really do believe that this conservative court is going to draw the obscenity line in a very different place than the Burger Court of the 70s.
Thank you so much, Con.
Thank you.
You can read more analysis from Con Carroll, news from the rest of our team at washingtonexaminer.com. Don't forget to like, subscribe, and share this video with your friends. Until next week, this has been The Debrief.